Bloom.
Welcome back to the Courtroom Breakdown, where routine hearings turn into absolute chaos. Today, we follow two defendants, Bloom and Harris, as they clash with the legal system in ways you won't believe. From driving into court hearings, literally, to explosive accusations against judges, this case has it all. Who's bluffing? Who's breaking the law? And who's just trying to survive the system? Stay with us, because by the end of this hearing, reputations, rights, and lives will be on the line.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Bloom, who is present.
What are we doing today?
Your Honor, I'm going to be asking the court to set this for the final settlement conference. I know there's one in August. I know there's one in June. I do have a circuit court jury trial for next Monday that's like pretty firmed up.
Got it.
But I can make the August one work, and I'll leave that open and we'll get it done.
Okay. Jury final settlement conference will be set August 9th, 2024 at 9 a.m. Jury selection in this matter will be August 12th, 2024 at 8:30. Both of those proceedings are in person.
I'll let you go.
I was going to try to get you. I was going to try to get you out of the room. Bloom. I was trying to get you out of the room before you said anything. You knew what I was doing. That's why your finger went up.
At least I'm not driving with a suspended license. Times now I've let it go. Remember?
Let what go?
I said enjoy the day, enjoy your horse, all that. So I let it go. The time before that, I let it go. But Your Honor, today I need to put something on the record. This is very serious.
Put something on the record all the time. Go ahead.
Okay. No, not last time. Okay. Your Honor, this case, assault and battery case, has gone over a year. And since October, I've fought tooth and nail for discovery. I still haven't been given a hospital report, any photos, any. There's a lot missing from discovery still. Remember, since October, we've.
No, I remember you mentioning it. But hold on a second, Mr. Bloom. Has the discovery been requested, Mr.?
Yeah.
Hold. This is why. Listen, Mr. Bernstein.
Which discovery referencing, Jeff? Hospital report that Deputy Swearing says there was a hospital report. There was. I'm wondering how this case was even brought about, Your Honor, because.
Okay, Mr. Bloom.
There was never a report,
Mr. Bloom.
Okay, I'll let it go.
Because you keep asking me questions you know I can't necessarily answer.
Okay, let me get on with the real stuff.
Oh, okay.
Her transcripts. No, I still haven't received the transcripts
of what?
3/6. Remember, I asked for the transcripts from 3/6. I still haven't received transcripts from 3/6. That's 3 months ago. I know it takes a while, especially this being a misdemeanor case.
Hang on. We have to have a written request for the transcripts. And Mr. Bloom, here's what I'm going to suggest. If you need those, again, you have an attorney. Tell your attorney that's what you need.
Okay, well, this is my assistance of counsel, just like Ms. Barroso has assistants and you have assistants.
I don't have assistants.
I can clarify what Jeff's talking about. I ordered an audio recording of that hearing. And someone in my office we did a transcription of it for Jeff. But I think what he wants me to request is an actual transcript. And I just didn't.
And so they can do that, pay for it, and I'm sure it will be accomplished. But if we haven't received a written request for that, then that won't happen. So.
Thank you. Well, I ain't going to go through all this. I just need to put a little bit on record. Per transcripts from 10-4, you stated that you believe everything a Washtenaw County Sheriff's 22. Washtenaw County Sheriff Deputy says is true. And you believe everything a Washtenaw County Sheriff's Deputy says.
Hold on a second. What are you reading to me right
now? Something that I want to state on record, Your Honor.
No, but what you're obviously stating what somebody else said. I'm just trying to figure out where it's coming.
You said.
On the 24th of.
No, on 10-4 of 22.
In this case?
No. You stated that you believe everything a Washtenaw County Sheriff's deputy says, correct?
I don't recall saying that.
And you were upset that my attorney questions the deputy's authenticity, and requested said officer to be under oath. And there is proof that deputy testified with reckless disregard for truth. You were also misled on 9/13, 10/4, and 11/7.
Mr. Bloom, is this in regard to your other matter?
This is regard to everything.
Well, no, it can't be in regard to everything. It's got to be in regard to your other matter, because this didn't start, no, stop. This case didn't start until 10/18. So if you're referring to a record from another case.
Then I'm passing 2A, Canon 3, which in part reads, a judge shall not initiate, permit, or consider ex parte communications or consider other communications concerning a pending or impending matter that are made outside the party's presence or their lawyer's presence. Canon 3A4B in part reads, not only is it a gross breach of the appearance of justice.
And here's where things explode. Bloom isn't just demanding evidence. He's now accusing the very judge of bias and improper communications. Let's pause here. Legally speaking, judges must avoid what's called ex parte communications, private discussions about a case without both parties present. Bloom weaponizes that rule, citing judicial canons like a self-taught lawyer on fire. But notice the tension. The judge flat out rejects his claims, cutting him off mid-sentence. This isn't just a legal dispute anymore. It's a power struggle over who owns the courtroom's narrative. Tell me in the comments, do you think Bloom is uncovering real misconduct, or is this pure courtroom theater?
When the defendant's principal adversaries are given private access to the ear of the court, it is a dangerous procedure.
What are you, Mr. Bloom? I'm going to stop you, because what are you talking about?
I'm talking about the transcripts from 3/6, Your Honor, where you stated you had notes, you stated you had a phone call from ex parte communicators.
No, that was regarding your dental?
Yes.
Yeah.
That was a motion we filed.
No, but that has nothing to do with the case.
But I mentioned that on
And
other days you did that.
Mr. Bloom, no, Mr. Bloom,
You don't
because
wanna
if you're
hear
going to, you don't want to hear, I don't. Because what you're saying is incorrect.
Okay.
I had a communication.
All right.
I disclosed that to the parties because it came to the court's attention, not by the court doing it, that there was something regarding the dental work. I don't know what it was about the dental work.
There were other matters you did the same thing, Your Honor. I'm not
Goodbye. Goodbye. Goodbye, Mr. Bloom. Goodbye. Thank you. Have a great day. Take care.
We'll contact the Senior Commission, sir.
Have fun.
Mr. Cox appearing on behalf of Mr. Harris. How are you, Your Honor?
We will see.
We're good. We're good.
Mr. Brown, or somebody from the PD's office, because I did not get a substitution. I got an appearance.
Oh, I've got a substitution right here.
Signed off on?
It is.
All right, then I don't need to address. I don't need to address the public defender's motion to withdraw. I'll consider that withdrawn, given the substitution. I do have an appearance, and I will sign off on the substitution.
Thank you.
Thank you. All right, what are we doing today?
So, Your Honor, we were going to, there are several options that my client.
Well, and I want you to know, counsel, that because of certain things, the court has a number of things I have to say.
Okay.
Because I think the record, given particularly some of Mr. Harris's comments with reference to this court potentially acting, what at least as I'm to understand is on what some may be, or is it, let's put it this way. People are saying, and quite frankly, your client has made the assertion that the Pittsfield Township, as well as this court, was acting on some type of defective or faulty information, which I will tell you, counsel, caused the court, given what the court did, to investigate what my ruling was. And I will tell you that that assertion is absolutely correct with reference to any faulty information that either came through to the Pittsfield Township Department of Public Safety or to this court ultimately at the May 15th hearing. And I think it needs to be stated, I've been asked for comments. I have refrained from comments as my normal practice is. This court with the pending case will speak on the record. And so I am going to make sure that the record is very, very clear as to what this court knows and what this court acted on May 15th. And we can start with this. And my basis for doing it is because of what was said about what this whole process was. And that an indication, counsel, and I know, counsel, you've been before me before.
Absolutely.
I know it is not coming from you, but you also know how I am.
I do.
And the thing is that if for whatever reason, the one time in my life I was wrong, I will say it and did. But when I'm not wrong and when people are not to blame, then it also needs to be said. So I will try to get through this as quick as I possibly can. But I will tell you, first of all, with any reference to your client having had a license on that day and some indication or misunderstanding as to whether or not he had a license, let me make it very clear, based upon what the court looked at, he has never had a Michigan license, ever, and has never had a license in the other 49 states and commonwealths that form up this great union.
We're back to Mr.
They suspended his license, and what people don't understand, when they suspended his license in Saginaw, they don't suspend the license. They suspend the privilege to drive in this state. Hence, for example, if he had had a Kentucky license, he would be able to drive everywhere that Kentucky would allow him to drive. He just couldn't drive in Michigan because his privileges had been restricted. I know you know that, but that wasn't at all said. But it doesn't matter because he didn't have a license ever. There is also then, and I will, when it is necessary, come to the defense of my sister courts, and I will come to the defense of Saginaw. They got a great chief judge. Chief judge answered the question. But I will tell you, that court and its friend of the court did nothing wrong. His license was, his driving privileges, better stated, were unsuspended in 2022. That required Mr. Harris to do something. He didn't do it. Therefore, that friend of the court was under no obligation to send anything to the Secretary of State. Now, I hated that I had to look at all of this, but when there's a question as to what I did, I'm going to look at everything to make sure that what I did was all in order. There's then an indication from that because that wasn't sent, there was a direct attack on Michigan's Department of Secretary of State's office, saying that the Secretary of State was somehow at fault. Let me tell you something. Secretary of State did what they were supposed to do. And in point of fact, they did nothing because they hadn't gotten anything from the court because Mr. Harris had not paid the reinstatement. This week, or the latter part of last week, once he paid that, Saginaw friend of the court did what they should do, and they sent it. Immediately, based upon the information that I have, the Secretary of State did what they do every day. They took that suspension off of his driving record, and he was then unsuspended. And then your client did what he needed to do with reference to the Secretary of State and paid a reinstatement. Okay. Just a second, Mr. Schiller. I'm going to let everybody respond because
Thank you.
I am not done yet.
Okay.
All right.
You covered a lot of the points for me. Thank you, Your Honor.
And so that came down to that. So the information at the time that I had, that Pittsfield Department of Public Safety had was all correct at the time of both Pittsfield stop as well as the May 15th day. It was all correct. There was no error by anybody. It was a failure on the part of Mr. Harris to do certain things. Now, I grant you that sometimes that can be a complicated process, but it was certainly not anybody's fault that that didn't happen other than that wasn't paid. Now, here's the other thing, and this stop was in October. Most of the cases that we've heard just in this last afternoon are driving while license suspended cases. That's part of my Wednesday afternoon. We go through great pains to try to get people their licenses back, which is really how it should happen. Between October and because I don't live under a rock, I actually watch things. You look very nice on TV.
Thank you.
You're welcome. There was something that was sad, that was very disturbing to me. And I'm just going to let you know because I believe in being fair with everybody. The question was asked along the lines, between October of 2023 and the point in time of the May 15th hearing, was there an attempt by Mr. Harris to correct his license? Here's the part that was disturbing for me, so that you know.
Okay.
Mr. Harris indicated that at some point he had been involved in some accident. Then being involved into the accident that he was basically bedridden or at least housebound, he could not get to the Secretary of State. That was set up there, and I'm going to presume, because my knowledge of counsel, defense counsel is, I know you don't misrepresent anything.
Right.
You never do.
Right.
That's not true.
Okay.
He purposely stated that he could not get to the Secretary of State, which, for the way we handle things in this court, would have placed him in a whole different category. We would have tried to find a way. Let's figure it out. And the reason I know that is because Mr. Harris, on December 28th of 2023, do you know where you were?
December 28th, 23.
23rd.
2023.
I know I was laid up from our
You were
accident.
at the Secretary of State's office. And you were at the Secretary of State's office because you redid and got your new Michigan 28, 2023. You did. And so that you also know, and in all fairness to counsel, because I don't know if counsel knows this or not, the way I know that he's never had a license is because May 3rd, 1990, he was 19 at the time. May 3rd, 1999, he applied for his first Michigan ID. Counsel knows, so I do. You cannot have both. You either have an ID or you have a license. One of the two. He has religiously every year gotten a new ID. And so he knows that he doesn't have a license. And quite frankly, I just wish he would have said that at the beginning. And all of this hoopla could have been just put all aside. And we all go through the process as we do with all of the people coming here to try to get him his license back. But his falsehoods, misstatements are not going to fare him well in this court. I'm done for now. I'm sure I will have something else to say whichever one of you would like to speak first, you may.
I'll wait to go last.
Yes, I spent yesterday at the Pittsfield Township Police Department with Officer Monaster performing the traffic stop in this case. I also noticed the December 28, 2023 date, and I know the significance of that, and the court just went through that painstakingly, and I thank you for that. In addition, at the traffic stop, when I was at the police department yesterday, we watched the body cam video. At least twice during this traffic stop, he acknowledged to the officer that he did not have a valid license. Quote unquote, quote, actually, I don't have a valid license, close quote. The question was, are you a valid driver? Quote, I am not, close quote. So, you know what, this is all this hoopla and the circus atmosphere is, in my opinion, is an affront to the justice system. I mean, I've been a prosecutor for more than 30 years, and to see this kind of hoopla around a driving while licensed suspended case is ridiculous. And it wasn't caused by this court. It wasn't caused by the Pittsfield Township Police Department. It was caused by the extrajudicial statements made outside.
So let's break it down. For Bloom, his endless challenges collapsed under the judge's authority, leaving him dismissed with a curt goodbye. For Harris, his defense unraveled when the judge revealed a devastating fact he never held: a driver's license, ever. No faulty reports, no system conspiracy, just his own failure to take responsibility. The ruling makes one thing clear. In this courtroom, facts rule over noise, and accountability is the only way forward. If you found this breakdown as jaw-dropping as we did, smash that like button, share your thoughts in the comments, and don't forget to subscribe for more shocking courtroom showdowns. Until next time, justice is served.